The licensing committee to order for the Tennessee State Board of Accountancy. We've got several items to cover today. I believe two of them are carryovers from last meeting. We'll just start with the top. The first one, we had a resubmission of the application for the accounting tools for the SSE ethics course. I believe at the last meeting we had requested some additional information, an outline of the course and more specifics, and they've provided that to us, and everybody should have a copy of that. I assume everybody's had a chance to take a look through it. Any discussion on that? I'd ask Mark and the staff to look through that as well, and you're comfortable that it covers all the criteria?
Staff has reviewed it, Mr. Chairman, and we feel that it covers all the criteria as required. So yes, I would think this would be a good course.
That said, assuming there's no more discussion, I'd ask for a motion to make a formal recommendation to the board for acceptance of this course.
So moved.
Have a second? Motion made, properly seconded. Any discussion? No more discussion. All in favor, say aye.
Aye.
All opposed? Motion passes. The next item, we have a request from Art Taylor for an extension of time to complete the CPA exam. Let me get back to that. Mr. Taylor had a medical condition, some nerve damage, where he was unable to work and therefore unable to study for the CPA exam. He's making a request for an extension for the financial accounting and reporting in the regulations section only. It says he has until November to complete the sections. Did he specify how long of an extension he was asking for?
Normally, when they request an extension, it's for a one-window time period.
I saw there was a doctor's note in there that said that expected to have be in better condition to be able to work this fall. He's just asking for, so basically a 6-month extension starting from November.
You can give him 3 months or 6 months, either one. One window is 3 months, 2 windows is 6 months.
Didn't specify though what?
He didn't specify, but I would give him a 6-month window.
Discussion on this item? What's the committee recommending for extension time period? Motion. So we have a motion to grant him an extension of 6 months from November of 2013. Do I have a second?
Second.
All in favor, say aye.
Aye.
All opposed? Motion passes. Next request is from the Knoxville CFMA for exempt sponsor status. Let's see. To the Knoxville Construction Financial Management Association. They're asking to qualify as an exempt organization. I've asked the board to do so. Mark, can you kind of explain what that means? Where that basically means they can grant CPE credit for their programs without having individual approval. Is that?
Yes, that's exactly what it means. It means
Okay.
They will be able to offer CPE for courses that they offer.
I was reading through their letter, and I see some of the topics that they had during 2012-13 meetings. They had a tax update, then they had a OSHA and TOSHA update, and then they had a business email. I'm not sure what that includes, but then there was a construction update on campus, a campus construction update. I guess the only concern I had was I don't know that particular program would qualify as CPE, and I don't understand the content of it, but I would just assume it's just a update on the construction at UT.
That would be my understanding,
So-
yes.
So if we granted this, would they be able to grant credit for that, or how does that work?
If you grant them exempt status, then yes, they can grant CPE for items they feel are appropriate for CPE.
What's the rule for, let's say we look at one of the courses and determine that really should not have qualified for CPE? Is that just,
If you grant them exempt status, then they have that authority, Mr. Chairman.
in past, well, we've done this before, have we given them some guidelines as far as what qualifies, or, I mean, I guess they're open to do what they think is right, but like, do we give them some criteria that they need to operate within?
In the past, we have not given any exempt organizations any criteria. We expect them to follow the criteria as established in the rules.
Pretty common request.
Not really, no, sir.
What's management's thoughts?
Management's thoughts are they probably should not be granted the exempt status. I'm just not comfortable giving every organization that comes along an exempt status.
My thoughts were it's not really an accounting-related organization. It'd be different from like a Tennessee Society chapter or that, that's related to our industry.
Correct, that was my thought.
Discussion on this or thoughts? Motion to grant or deny?
Motion to deny.
I'll second.
Motion to deny and a proper second. Any more discussion? All in favor say aye. All opposed? Motion carries to deny. The next item is a request from Richard Brown. Let's see. Get to that. The review of the CPA application of Richard Brown. Mr. Brown, as well I understand it, has passed all 4 parts of the CPA exam, and he's also passed the ethics portion of the exam, and is waiting for. Has he been denied? He hasn't been denied. We're just wanting to discuss his application because he's got some criminal background that showed up in his background check.
Yes, that's correct, Mr. Chairman. I believe that Ms. Condon has passed out to you in hard paper copy the rest of the TBI report, and that is what was missing from the iPad, and I apologize for that. But if you look on page 2, that's where it references that it was a felony conviction for his second DUI.
Kind of summarize, he presented us with a letter stating his past. In his past, he'd made some bad choices and resulted in these charges, and I believe it's been over 10 years, if I'm not mistaken. Is that 10, 12 years, something like that?
That
1998.
charge appears to be 2002.
Okay.
11 years. And in his letter, he's stated he's turned his life around and got his accounting degree, and now he's passed the CPA exam, and he's just requesting that we grant him approval for his CPA certificate. Any discussion on this?
I think the fact that he hasn't had any more trouble in 11 years suggests he's not.
I would agree too. I mean, we all make mistakes in our past, and obviously it's about a person that turns their life around, giving them a second chance. So, with that said, do we have a motion to approve issuance of his CPA certificate?
So moved.
Second.
A motion to approve and a proper second. Any more discussion? All in favor say aye.
Aye.
All opposed? Motion passes. The next item is a request. This is a carryover from the last meeting. I think Matt Walden had completed the coursework at the Graduate School of Banking. I believe it was LSU. Is that right? It was LSU. And he is asking that that this course, he'd be granted CPE credit for completion of this course. Let me get to the... It is the same course. Any discussion on this? I believe there's a listing of, he's got a pretty extensive listing of the courses that he took in the, if I can get to the right page. I guess my thoughts are some of these courses, definitely fall in under the accounting industry as being related to. I don't know what type of CPE he's actually requesting. I assume he's asking for just general CPE. He's wanting to count all this as A&A. I don't really see how it relates to the audit field specifically, if that's what he's asking for.
I think he's asking to classify a good bit of it as management advisory.
Mark, what's the protocol on this? I mean, is this something we could piecemeal out, or we either have to approve the whole course, or?
I'd hate to try to piecemeal it out. I think that it needs to be approved or denied in whole.
Evidently have a precedent where it's been approved in the past, if I'm understanding Ms. Conlon.
Yes, sir. That was, 12 years ago, 2001? You do have a precedent, Vic, but it's a 12-year-old precedent.
Mark, you've reviewed this more in depth. What are your thoughts on the course?
Even to be truthful, I can go either way on it. We do have several candidates who are in the School of Banking, the LSU School of Banking. This is very similar to that, in my opinion. At this point, I'd argue for approval.
Asking for general management CPE, and just kind of reading through the courses, you've got several management classes. I think if he was asking for some specific A&A type CPE, that would be a different. I'd have a different opinion, but at this time, I don't. And based on past precedent as well, I think that I would not have a problem approving this request.
For management advisory service credit.
We have a motion to approve this as credit for management advisory CPE.
Motion to approve for management advisory CPE.
Have a second? I'm getting dizzy looking back and forth there.
Like a tennis match.
Should have sat together.
Yeah. All in favor, say aye.
Aye.
All opposed? Request is granted. Motion passes. And the last item we have is a request from Laura Wright to extend a few sections of her CPA exam. Let me get to that page. Kind of an overview. Ms. Wright, she sat for the AUD section of the CPA exam in July of 2013. During the exam, she became ill and had to go to the emergency room where she was diagnosed with food poisoning. She passed the AUD section previously, but the section expired. And she was planning on taking the AUD and reg section during July, which would have, theoretically, she would have completed and passed the exam. Because she was unable to finish the AUD section due to her illness, her BEC section will expire, and she'll only be left with reg and FAR credits. So basically, she's requesting that we give her an extension of the BEC credit. Is that correct?
Yes, sir.
I guess the only concern I had with that is she's making the assumption that she would have passed that section. If she had taken it and not gotten ill and not passed, she would have lost credit for it. So we have to make an assumption that she was going to pass that section. Open up for any discussion on this.
She indicated she had passed it before but let it expire. I don't know if that means.
Well, I'm a little confused. It was food poisoning, but she was sick for a month? Left the exam sick.
What did you pick up on the month, being sick for a month?
Well, it says, so she sat for reg on the 25th. Sat for audit, I guess on July 1st, and then got ill and had to quit.
During the exam, she got sick and had to go to the hospital or I guess to the emergency room. I guess my thoughts, the only issue we have is that we don't know if she would have passed the exam or not. Yeah, she's passed it previously, but that doesn't necessarily mean that you would pass it the current sitting. So we would be granting an extension based on the assumption that she would have passed that portion.
And I guess I'm a little skeptical because she seems to be, I see a little bit of a history here. She let audit expire, and then she was in it again. I mean, like a pattern, and she wants another extension.
More discussion? We have a recommendation for the board.
I'm on the softer side, so everybody knows that. I would suggest we give her a 3-month window. That's a fairly short fuse within which for her to get it, and if she doesn't, so be it. I mean, either she passes during that window or she doesn't. If we're concerned about the validity of her story, then we can request documentation from the hospital to prove that.
She sent that.
Okay.
She showed the documentation of going in that night, and it was.
I mean, I'm like you. I don't know whether she would or wouldn't have passed, but to me, the appropriate thing would be to give her a short fuse, go in there and take it, and either you pass it or you don't.
I'd be curious what time her test was. I don't know what time she actually got to the hospital.
I have a lot of students that would try this same excuse. I used to be softer.
No, I'm talking about, I mean, one window to go get her test and complete it, whatever that next window is.
December.
Right.
So no.
Next window would be more.
The next window would
It's
be
January.
January, February.
January and February.
So she's going to
Give her
miss
until March
this window.
31st.
My thought is give her one window, which gives her one chance to sit, and if she doesn't make it, then she loses it.
And I have corresponded with Ms. Wright, and she did pass the reg section, so she has 3 credits under her belt. It's like if we don't let the BEC expire.
A general question, does this open up problems for the future if somebody, does this cause us additional problems if we open this up? Does it open Pandora's box to where now we've got other people?
Medical excuse here, whether you buy it or not. I mean, I don't think anybody can just walk in and say, grant me an extension without cause, in which we.
Well, and I think you can also distinguish it, because your average person probably not going to come in having passed previously once before. Now, whatever weight you give that or don't is fine, but if you're looking for a way to distinguish it, then, from just your average generic, well, I want an extension, but I have no history, then that's how you do it. And you say, hey, look, there's a medical excuse here, we have documentation, and she passed before, so there's, some possibility greater than 0 that she would be more likely to pass again than maybe somebody who hadn't before. Not guaranteed, but I'm just trying to give you guys something to work with so that you don't end up down that slippery slope that you seem to be describing.
Any more discussion on this? Vic, do we have a motion to grant her a 3-month extension, I guess beginning in November for 3 month, for the next testing window of 3
Is
months?
that correct, Mark? No, beginning November 1 for the next testing window?
I believe if you'll give her until March 31st, that will give her the January, February window in which to take the exam. That's what she needs. That will be the next testing window. Yes.
Motion would be to grant an extension till March 31st to give her one chance to take this second.
We have a motion to grant her requests to March 31st. Do I have a second?
I'll second.
I was gonna die for failure to get a second.
Hope she's a better accountant.
You made me a believer too, Vic. All in favor say aye.
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 Extension is granted. I think that covers our agenda. Do we have any other items we need to discuss?
No, sir, not from the staff.
With that said, I would request or move that we adjourn. Give me that gavel.
Well, there is gavel down here.
I'm gonna bang on that thing.
We have to wait till the
Executive committee meeting to order. Get myself organized here. First thing on the agenda is to review the financial information. Mark had submitted the budget year-to-date with some written documentation as to changes and things of that nature. So I'll open the meeting up quickly here to for questions on the actual financials themselves.
Appreciated getting the discussion and analysis because in addition to the schedule, understand what's going on.
Yes, sir. Glad to provide it. I did want to point out to you the one significant change is the state change in how they compute the regulatory fee. Previously, they had been assessing us a $5 fee for all the licenses that had been issued as of June 30th of a given year. When they did the performance audit for the department, the comptroller's office decided that was not an accurate assessment. So now what they're doing is they're assessing us for any license that is issued during a 2-year period. And if it's a 2-year license, so they're charging us a $10 fee for each license on those transactions. And that is why the regulatory fee went up as much as it did.
Well, but that will equalize over time, right?
It will equalize over time, yes. They're basing it on renewal transactions and issuance transactions.
Right.
And Mark, you're speaking to the, I guess I'm looking at the operating results comparing year-to-date June 2013 to year-to-date June 2012, which will be the full year. You start off with the revenues there and then less state regulatory fee, and that's where that state fee is in these financial statements.
Yes, Casey, that's correct.
And that shows from 2012, that fee went up from $59,050 to $86,065.
Yes, that's correct.
And again, we should see that kind of equalize itself in another year.
Over the next couple of years,
Yeah.
yes.
Okay. That's the only question I had in reviewing the information ahead of time, Mr. Chairman. I don't have any further comments or questions on the financials.
And Mark, I guess we closed out the year with a net surplus. Was it, about $52,000? Is that about right?
Yes, sir, that is correct.
And are we good on our chargeback numbers? Is that was finalized, I guess, before?
These are the latest numbers they have given me. This is the second close, and as far as I know, it's the final close.
Do you think these are good numbers?
Yes, the 179, 542, 88 from the department should be the final number.
Second on the agenda is the travel information, and Mark had kind of forwarded some of these documents to me prior to this meeting, just to see if this is what we wanted. And I guess, Mark, what we've got here is travel by employee. And then we're doing it kind of comparative so we can kind of get a feel. I know with your new role and everything, we're trying to be conscious of our travel budget and expenditures. Because we know you'll be traveling some with the your role in NASBA. So I like this format. I guess the one question I had kind of related to travel, where do we stand on the online CPE for ethics?
We have done a dry run-through, and we are scheduled, I've got to get with Evans Murray. We're going to offer that late November and probably one in December.
Okay.
So we'll have 2 offerings before the end of the year.
Okay. And will this be a system whereby you can go on at any time, or will it just be at certain times of the year? You're just doing like a webinar? Is that what we're doing?
Exactly.
Okay.
You have to sign in, and then we'll give you prompts during the presentation.
So it'll be like a live event. You'll just be doing it on your computer.
Exactly.
Got it. Okay.
Mark, if, looking at Don and Ray's travel, it would indicate that there was no travel related to investigative work?
I'm sorry, Mr. Blofus, I thought that I was only asked to provide travel in regard to the ethics presentations. So yes, there was travel in regard to investigations work.
I think we need to add that back in.
Okay.
Let's just do a comprehensive travel. I mean, we don't need to know where they went necessarily, but just not to each individual office or anything like that, but just so we can get a feel for where everybody's, what they're doing and where they're going. And I think.
Mark, based upon your travel schedule, is this an indication of about how many days on Tennessee board work that you're out of town in July and August, and September?
Yes, sir. This is a good indication. I was out more in 2012. Clearly, we had more invitations to speak in 2012. This is kind of a every other year type thing for some people. And two, I've cut back in my agreement with the assistant commissioner to cut back my in-state travel.
Any questions? So you'll revamp these, and we'll look at those at maybe the next meeting or something. I mean, I don't know. You're not gonna be able to prepare that for tomorrow, anyways.
Oh, no, sir, but we can get it for you for the next meeting.
Right. Okay. Any other issues, questions?
No.
All right. I move that we adjourn.
Second.
Or can I do that? I don't know if I can.
I'll move that we adjourn.
All right. So moved.
Good.
All right. Oh, Mark, I know what we were going to ask you. We just read where the reimbursement rates went up for board members.
Yes.
And then, was it Don was telling us that they pay for us to do valet parking, but they don't pay for us to self-park? Is that an accurate statement?
Oh, they will pay for parking any way you
Period.
do it.
Okay,
Yeah, as long as you get a receipt.
got it.
When you travel, or you and the investigators travel, and particularly on the NASBA work where we're going to have to pay for it, you're limited to that per diem or that hotel charge?
Yes.
And so when it runs
Well,
over,
no, let me.
They limit your speed. I furnished 3 of the 4 cars last time. I'm not, looking back, my tire wear was excessive on my S2000 because it's.
Mr. Royston, if you're ready to start, we're on the record. The attorney is
Chris?
upstairs. He is upstairs getting the supplemental report.
Okay.
That was on the iPads, and Ms. Condon took the iPads to reload them since she missed some things the first time around.
Okay. Call the probable cause committee to order. Mr. Mills, would you like to update us then on the status of open complaints, please? I believe each one of you have been presented a copy of the report.
Yes, sir. Thank you, Mr. Chairman. You have a year-to-date of open complaints. You can see the trends. I think you're going to note in the cases that the board will be hearing this meeting, we're going to see a drop in, I think, 3 from litigation monitoring. We'll see a change there. Legal has 16 cases, which I think you'll probably be hearing 10 to 12 of those. So we've got everything pretty much in order. We do have a bunch of open cases right now. I think we've got 11 that are out for response. Those will be coming in. They'll be going to legal and hopefully then to Ray and I.
All right. How many are new cases? If you read the presentation here, how many were received in this last, or is that in there?
No, sir. You'd have to track them because some come in, we get responses, they go to investigation, reports go back. They would be sitting in legal right now because they have not been heard by the board. That's it.
I was just curious of the activity and the rollover. I know Mark had mentioned, I think, that that there's a bunch coming in probably in this next time frame because of the unpaid privilege taxes that we've received now, so new cases to open.
Revamp. This is kind of a balance sheet approach. Maybe I need to kind of do an income statement approach.
Any way you'd like to do it. Are there any questions? Hearing none, we'll accept this report. Thank you, Mr. Mills. Mr. Whitaker has just replaced the iPad with a tree,
A small tree.
a small tree, within budget. Number one, appreciate you sending out the preliminary report on cases so we could save some time during these. Would you like to proceed with your presentation of, I think each one of you all have had a chance to read the 15, I believe it's 15 cases that are on the list. Would you like to make your presentation, Chris?
We'll do that, if it's all right with you, Mr. Chairman. I'd take Mr. Joseph's report
Okay,
first,
sir.
since there are only two matters on there. As of right now, these are redacted, even though notice of hearing and charges has been filed on one, but not on the other one. So just in the interests of better safe than sorry, Mr. Joseph left these redacted for the time being. Item number one, this was a licensee who was charged with failure to pay privilege tax for at least 2 years as required by law. Over the course of a couple of years, she had been sent a consent order on 2 occasions by me. Then the case was referred to Mr. Joseph, and he filed a notice of hearing and charges, and the respondent got back in touch with Mr. Joseph, and they were able to work out a tentative agreement, which would involve a $750 civil penalty plus $200 in investigation and hearing costs, which, you know, is a standard fee for filing a formal hearing that doesn't ultimately have to be heard. In addition, we already have a letter on file from the respondent, or not from the respondent, but from the Department of Revenue regarding the respondent's privilege tax liability, and for the 4 years which she was ultimately delinquent by the time this got to Mr. Joseph, she is now paid up in full, including interest and penalties, and has a zero balance. And the respondent has already agreed to and has signed an agreed final order for the $750 civil penalty and $200 investigation and hearing cost. Mr. Joseph recommends that the board approve this agreed final order, which would dispose of the formal hearing, and I concur with his recommendation on item number one. Item number two.
On item number one, is that include the 4-month extension in this January 14th date, or is it?
It does. That is, I'm sorry, I should have covered that as well. Basically, it's a payment plan because of the lump sum that the respondent had to pay. It was over $2,000 by the time she finally got around to paying it all. So she requested a 4-month payment plan, splitting that up into equal payments. Once the agreed order is signed, if she misses any payments, her license is revoked automatically with no formal hearing necessary.
Thank you, Mr. Whitaker.
Item number two, this is a matter that had already come before the board. I believe that the board had previously authorized a consent order regarding the allegations, which were misuse and misappropriation of funds for his employer, which was a municipal utility district. The board's prior offer was a $5,000 civil penalty and voluntary revocation. It was back in 2011, and respondent rejected that offer at that time. However, once that offer was rejected, the case was referred to Mr. Joseph, and although formal charges were not filed because it took a while because we were waiting for the criminal court case to run its course. We had information that the respondent had been indicted over in East Tennessee regarding these same allegations in criminal court. Originally, we just didn't know if he was going to plead guilty or go to trial, but shortly before his trial was scheduled to take place, he pled guilty to 2 Class B felonies, one of which was theft over $60,000. The other is fraudulent use of a credit card, and got a 10-year sentence with all but 10 days of that to be served on probation. Also had to do 400 hours community service and to pay a $10,000 special assessment to help needy families with their utility bills. As Mr. Joseph points out, not only obviously did the respondent lose the job with the employer that he was accused of stealing from, but an additional job as well. He had insufficient funds to hire counsel, so he was represented by a public defender in his criminal case, and he's lost his home and now living at home with his mother, essentially. And based on those things, we just believe it to be highly unlikely that any civil penalty of any amount could realistically be expected to be collected from this respondent, because he's got so much on his plate that he's got to pay to criminal court. I mean, the good thing is the utility district, his former employer, was made whole, so they're not owed any money. Anything that was alleged to have been stolen from them was paid in full. But given the financial issues, you have to take into account the economic deterrence. If he can't pay it, then it really doesn't matter. But the respondent did agree to a voluntary revocation of his license. Mr. Joseph and I are of the belief that that would accomplish the goal of getting him off the street and keeping the public from being harmed. And considering that other than civil penalty, that's a maximum penalty that we could obtain at a formal hearing anyway, and we have an agreement to that as reflected by a signed consent order, Mr. Joseph and I both recommend that the board accept the consent order for voluntary revocation of this respondent's license. So at this time, entertain discussion and questions. If not, I need a motion and a vote to approve Mr. Joseph's supplemental legal report first.
Thank you, Mr. Whitaker. Does anybody have any questions?
5 years that he could ask for reinstatement in 5 years, that's applies to everybody, right?
It can. It's that is the maximum set forth under the Accountancy Act, that the board can say you can't even reapply. Now, even at the expiration of that 5-year period, the board is under no obligation to give someone back their license, but that is the longest time that the board can say we will not even entertain an application from you.
Always been my understanding, if you commit a felony, you lose your certificate forever.
Well, if you can get a respondent to agree to that, I suppose it's possible, because there's a little more flexibility in a consent order than there would be at a formal. But it's been my experience and the experience of other litigation attorneys in the division that if your statute gives you a period like that, if you take it to a formal, that's what you're going to have to live with. In this case, I don't want to say I don't think it matters at all, because 5 years versus permanent is a different situation altogether. But I just go back to what I said before. Given that we're getting the maximum penalty that we could get at a formal, and he probably would not agree to a permanent revocation, still recommend approval, but I understand what you're saying.
Further questions? Do I have a motion? Do you need a separate motion on each one, or just to recommend to the board the approval of Mr. Joseph's recommendation to the full board?
If you're going to approve them both, one motion and one vote will be fine.
Approval of both the reports. Do I have a second? Have approval. I have a motion and a second. May I have a aye signifying the approval?
Aye.
Opposed, like sign. Motion carries.
Thank you, Mr. Chairman. Moving on to my legal report. As you pointed out, there are 15 items on this report. A couple things to point out before we get into the specifics. After conferring with Mr. Mills, it looks like on number 10, Mr. Royston will need to recuse himself due to potential personal knowledge of the situation. And also, after additional discussion with Don and given the penalties recommended for other similarly situated folks, not only in the past but also within this same report, I'd like to change my recommendation to letter of instruction with cease and desist language as opposed to a dismissal. That way, we have something that says, that's in writing that says you have to do this, and if you don't, you're subject to further penalties. And that's typically what we get for first-time flyers through the, using the wrong language or inappropriate words.
That's number 10.
Yes, sir, that's correct.
I think each of you has had a chance to read these since we got them early, and I thank you again, Mr. Whitaker, for that. Helps the thought process.
Chairman, before a potential vote, I don't know if you guys are to that point yet, but would like to specifically direct the committee members to number 15. The recommendation there is somewhat fluid, and I'll be honest, I could be persuaded maybe to go a little bit lower, a little bit higher, depending on the committee's will. That's just kind of where we settled in, but it's not hard and fast.
Could we take 15 separately, please?
Sure, that'd be fine.
Will help me out with these. I believe 1 to 3 are remove the complaint from litigation monitoring and dismiss the complaint. Vote on those 3. Then discussion based on the recommendations of Mr. Whitaker on these.
I move approval.
Proper motion and second. All in favor say aye.
Aye.
Opposed, like sign. Okay, number 4 is recommending a formal hearing with the authority to settle for consent order. Discussion on that particular one, since it's a professional privilege tax. And number 5, closed complaint would issue a letter of warning. 6 is closing complaint with a letter of instruction to cease and desist, which I think you were referring to being similar to the other one. Listen to complaint on 7. 8, close the complaint with letter of warning. Do those through there, because number 9's a little bit of a different animal. Let's take, just to keep them going there, do I have a motion on those to, it'd be 4 through 8?
Second.
Proper motion and second. All in favor say aye.
Aye.
Opposed, like sign. Is there anything particular on 9 that's out of the ordinary other than what's on the face?
I think number 9 is pretty straightforward, and I think I concur with management's recommendation on that one. It's pretty standard, just allegedly, apparently, several times to do so and just didn't get it in. I mean, I understand firm and your main employee got sick and then left, but hey, you're the owner and managing partner of the firm, and that's your responsibility. And like, if he hadn't been given any chances, or maybe just one chance to come into compliance before a complaint was filed, maybe that would be a little bit of a lower recommendation, but I think it's reasonable.
Thank you. Number 10, Mr. Whitaker alluded to a little earlier, changing that one to letter of instruction and cease and desist. I think the others are closed with letter of warning. Thirteen. After reading it earlier and then again today, there's nothing special about that one except the kept operating the firm, and
I think it's a little bit of hindsight is 20/20. You know, probably something that seemed like a good decision at the time. If you were thinking, if she was thinking, well, I'm not going to need to have my firm permit anymore, but then turns out she did, but you know, maybe just didn't do what she had to do to get it reactivated. I mean, beyond that, it'd just be speculation. So you just go with the facts as they appear to be, which is you request your firm permit be closed in 2011, and then you're through 2013, still operating. So you get the $1,000 civil penalty plus the fees that you should have paid during those years if you were operating. And, you know, you've got to get your permit reinstated as well.
thank you, Mr. Whitaker. The others are through 14 are along the same lines. Do I have a motion to approve the discipline that's pointed out on 9 through 14? And I'm recusing on 10. I have a proper motion and a second. All in favor say aye. No by signifying by say no. Approved with let the record show recusal on 10 by myself. 15. Want to make any more presentation on 10 or?
Well,
I mean on 15, excuse me.
it's, you know, it does seem like there's a little more to it than meets the eye. You know, Ray investigated this one, and I had some additional discussion with him about it this afternoon. A little, obviously more than a little troubled by the respondent's prior history of felony conviction and going to jail and losing his license, and you know, eventually got it back, but you know, then is back before the board with alleged problems with his employer and potential problems with clients for, you know, work product issues. You know, one thing, and I tried to communicate this in the write-up, but the respondent's attorney argued strenuously, and probably not without some merit, that the real thrust of this matter is an employment dispute between the respondent and his now former employer. It appears, even though no one has come right out and said it just this way, that the firm was upset that the respondent left and some clients of the firm ended up going with him. I think that attempting to wield the regulatory power of the board as leverage to direct or harm someone's career is a good thing? No, I don't. Is it possible that this happened here on the firm's part? Probably. Could be. Could we prove it? I don't think so. And that's part of the issue. Again, you can, you know, Ray can speak for himself, but it just seems like if you're in a time crunch and you got to get something out, otherwise the client gets interest and penalties and the tax man coming after them, and it's either sign the initials or cost your client thousands of dollars, it doesn't seem like a hard choice to me. I mean, it might be violative of an internal firm policy for some reason, but, you know, what's the alternative? I mean, sometimes you choose the best of a not great set of options, especially when the folks who have said, well, you've got to obtain our signature, are nowhere to be found. All that being said, the file does contain some evidence that there was more than one client that not very happy with the respondent's work product. I think to proceed to a formal hearing with that, we would probably have to get a little bit of additional documentation and see what kind of witnesses we could line up before making a decision as to whether to actually move forward with that or not. I guess what I'm saying is, in light of the respondent's prior background and the totality of the allegations here, it seems like there is some smoke and potentially some fire, you know, possibly not enough to take his license again, but also probably not enough to just leave it be either. And so that's kind of the struggle and the thought process of trying to come up with some discipline that takes into account that the complainant, by almost any measure, doesn't have entirely clean hands here. But that's a mitigating factor, not something that negates or offsets any potential misconduct that the respondent engaged in. So, and I hope I haven't confused you any more than my write-up may have, but it's just not the easiest case. And, you know, if you want to ask if Ray has any thoughts, you're welcome to, but that's kind of the additional material to consider with this.
Clarify, is his alleged misconduct the fact that he put initials on some work papers? Or is there more to it?
Well, according to his employer, former employer, the complainant, they are saying that the reason that they made it so that a partner had to initial off on his work was due to concerns regarding the standards of his work product.
Quality.
The quality of his work. And that this was functionally a demotion for the respondent because he used to be able to sign off on these things himself. But because of their concerns about his work product, he was no longer able to do that. But according to the employer, he did it anyway to circumvent firm controls.
Misconduct is him fraudulently putting these initials on work papers.
That's part of it. The second part is, even though it wasn't submitted as part of the additional complaint, once we got the response in from the respondent's attorney, the employer sent in some further documentation reflecting pretty strong lack of satisfaction from, what was it, 3 different clients? Yeah, 3 different clients for everything from allegedly not getting tax documents filed on time, causing IRS to start calling them, you know, not getting what needed to be done, and assets being held up or frozen or whatever. Just a variety of things. So
I'm a little confused because on the one hand, it sounds like the employer contends that this person is a staff person under their supervision, that the whole complaint is that he's under their supervision. He violated their rules by fraudulently indicating that it had been reviewed. But then you're telling me that customers or clients are saying that he didn't get stuff out on time. So, I mean, pick one. I mean, are you responsible ultimately for the client's satisfaction, or are you being supervised?
fair question. One that I that I don't have a clear answer to, because unless I missed something, I don't think the firm ever directly just came out and said it, did they, Ray? I mean, even,
Initially, he wasn't, you kind of already covered it. Initially, he wasn't being supervised.
Not initially?
Right,
Okay.
initially, but then they decided they were gonna initial.
But they were having
everything he
some
did.
issues, I'm
Yeah.
assuming.
Yeah, so he was, but he wasn't.
Okay,
You are right.
okay, well, thank you.
I think they were confused.
Okay.
and something else to bear in mind, that I don't know if it muddies the water or clears it, but the file also contains a couple of affidavits, or, I think of them more as internal firm HR documents, where one of the named partners at the firm has written out things that the respondent has allegedly done wrong in violation of firm policy, and in each case, the respondent signed off and agreed that he had done those things. Now, I'm also not unmindful of the fact that if you want to keep your job and you're facing the prospect of either signing a piece of paper or being fired, you're probably going to sign a piece of paper no matter what it says. But even so, once you get to about the second or third one of those documents, what are you doing that's causing that to keep happening?
Why didn't the firm accept his resignation?
Well, if the firm's explanation is to be totally believed, and frankly, I'm not sure I do, but if you take it at face value, they thought, well, as long as he's here, because apparently he was a good salesperson and was good with the clients personally. So that's part of why the firm wanted to keep him on. And they felt that as long as he was under their roof and their supervision, at least up until they felt like he didn't need to be there anymore, that they could minimize whatever harm his alleged misconduct would reap upon the public. I find it a little... I find that it slightly contradicts the firm's explanation that they waited almost a year to file this complaint. And if they thought that it was serious, it's at least arguable that they had an affirmative duty to report misconduct if that's what they thought it was, but that they didn't do so. And frankly, it looks bad that, originally, you're saying the guy did all this stuff wrong, but you let him keep his job right up until the moment you don't. And then when you find out that he's got several clients that used to be at your firm but that now are with him, then you file a complaint. I mean,
They're not alleging he violated some kind of non-compete agreement, confidentiality, or anything like that, right?
that's one of the few things that's not in there.
But what you're recommending, that he be put on probation for 2 years?
If he hadn't been revoked before, I probably wouldn't have recommended that. But if the committee and the board as a whole believes that there is any level of discipline warranted, I think probation probably ought to go with it.
But probation, if a practitioner is on probation, that's not public knowledge, right?
Someone would have to call and ask about it.
When you pull someone up on the website, if you're doing a license search, then yes, it will show his license as being on probation.
It doesn't
That
practically.
really requires a good deal of initiative on somebody's part.
It does. And functionally, it doesn't limit a licensee who is on probation. It doesn't limit the scope of their right to practice unless the order that they signed says it does. So basically, it's like, look, you're really under the board's microscope for the next 2 years here, and if we get anything else on you that's proven up, your license is probably gone.
How did we come up with, 2 hours of state-specific ethics?
that was,
And what is he gonna learn in the extra 2 hours that he didn't in the required ethics period?
your question is not without merit, but just like there are times where the English language fails, there may be,
This one we're gonna do with a hammer or something, or?
I don't know, maybe. But it's,
What I'm hearing is a good deal of sympathy or being an advocate of this person who's the complaint's been filed against.
I wouldn't necessarily say that I'm advocating for them, because obviously he certainly hasn't hired me and that's not my job. But at the same time, I was, having been a public defender for a couple years back in the day, I always felt pretty strongly that if there was any potentially exculpatory evidence or mitigating evidence even, that the person who was being accused of whatever it was had the right to a fair airing of that as well, just as much as the complainant has a right to a full and fair airing of their allegations. And so,
Fellow has a track record. I mean, he was convicted of filing a fraudulent tax return. So he doesn't have a stellar record.
I absolutely agree with that.
And I guess I was going to wait until after we resolved this to raise the other question. Why isn't there a complaint filed against the firm? Because the firm hired somebody that had had filed a fraudulent tax return, and they didn't provide, it appears to be, appropriate supervision of one of their associates. I mean, I think they're just as culpable as this fellow. I mean, how did they find out that, he had initialed something that he wasn't supposed to? The supervisor should have been available to review it, and even though there could be a penalty, I mean, that's the problem of the firm and not necessarily the staff accountant.
Well, I guess the first and most obvious answer is because at this time no one has filed a complaint against the firm. No one has opened one.
But based upon this information, we can initiate a complaint, can't we?
I mean, it's
But
entirely
Ray,
possible.
I guess in your investigation of this, you didn't feel that there was any deficiency of professional performance on the part of the firm? But why would a firm hire somebody that had filed a fraudulent tax return?
I guess the same reason this board decided to give him his license back.
Well,
Well,
I
and-
don't think I was here at that time.
I mean, that's, I mean, if we're gonna go on a witch hunt, let's go get
No,
us too.
and if I did, I wondered where my head was.
Charged with fraudulent tax return.
Go ahead.
He was charged with a fraudulent tax return because what he'd done is embezzled money.
Only compounding the problem.
It's the old Al Capone strategy.
Yeah.
But
Facts of the case.
It was like 97, 16 years.
and let me also add something to. I mean, Ray didn't. Again, he didn't say it just this way, but I got the impression from reading Ray's report that what the firm did was more tacky and in bad form, as opposed to the respondent here, who, under any set of facts, is probably dealing with at least some law and rule violations. Because if you look at the documents in the file as Ray and I have, I think you'd be hard pressed to make a case for lack of supervision, especially when you've got this veritable river of documentation over a year's worth of time or so, where they've tried to rehabilitate this guy, give him a chance to, fix it or not do what they said he was doing wrong, and he agreed with what they said he was doing wrong, and it just didn't happen. I mean, if you're at some point you cross over from being a regulator to telling somebody how to run their business, and if they made a business decision that for whatever reason or reasons that they thought, okay, we can simultaneously keep this guy on for whatever benefit he brings to the firm, but also maybe minimize or help keep him from harming the public by keeping him under our roof and under our employment, and see if we can rehabilitate him again, I guess, then that's kind of their call to make and their risk to take.
But I go back to Ray, when you did the investigation, you did not see any cause to file a complaint against the firm.
Meeting.
Hurt anybody. But then when they saw him go back to work.
Yeah, and they found that out by probably half a dozen or so requests from now former clients of the firm asking that the firm send documents to the respondent because he's now doing their work.
They did not terminate him, is that correct? He quit to retire, is that what I'm understanding?
Mutual agreement was reached that due to his medical issues that he was no longer essentially physically fit to continue working, and so that they agreed to part company on that basis. Got a license.
With more clients from his old firm.
Yeah.
Yeah, I move that we accept the recommendation from legal counsel for 2 years of probation, $2,500 penalty.
Second?
Second, I've got to vote for it.
No. Oh, would you like me to second it so you can have discussion? Okay, I'll second that motion.
No, I
We have a
just-
second and we have discussion now.
I don't think there's any good answers here. I have to defer to the judgment of management, but firm, when they hired him, know that he had filed a false tax return?
Yes.
I agree with you, but this side, they may open a case and see if there's something on the other side. What we've got to deal with is this adequate
Go ahead and call.
punishment or whatever for what we think has happened here? Call for the question. All in favor, say aye.
Aye.
Opposed, like sign. The motion carries.
Keep in mind, if this proposal is not accepted, this doesn't obviously bind the board if he comes for a formal, which I couldn't recommend against strongly enough, but who knows?
But it would give the board the opportunity to ask questions if he chooses to do that.
Yeah, that it would.
That's all that's on the legal report, and smack me if I'm asking a question that I shouldn't be asking for tomorrow, but I assume at some point, we have the matter of Edward G. tomorrow. Edgar G.
Yes, he is on the agenda for the full board's consideration tomorrow.
Is there any consideration that this committee can or should or will have going forward to that?
If the committee has a strong opinion one way or the other, you're certainly free to voice it and to pass along a recommendation to the board if you have one. But given that the full board has already rendered its decision in terms of what settlement would be appropriate, and that settlement has been accepted, and the only question to come back before the board is whether the board wishes to modify that or not. Because the settlement was agreed to by the full board, the request for modification should probably be for the full board as well.
What is he asking for? Or what is the question we're going to consider tomorrow?
He was given 2 years probation
Yes.
as part of his consent order, and I'll be honest with you, that was one of the consent orders that I liked the least having to do, because he was suspended from practice before the IRS for something that this board and our law and rules do not consider to be a violation. They got him for what they deemed willful failure to pay taxes, his own. And laying aside whether you think it was established that it was willful or not, I have my doubts, but that's not even something that this board says is a violation. However, you get suspended before a state or federal agency, that is. And I think the board giving him a $500 civil penalty and 2 years probation on something that would usually be much harsher is reflective of that. The reason, as I understand it, that he's requesting a modification because he wants to teach some courses, and
Excuse me. And frankly, that's my problem with it, knowing the name that's attached to it, to the set of facts that we get in the other form, is that he's been out here teaching tax courses on how to, over the years, as one of the featured speakers by our own society and all over the country, is a premier speaker on how to massage the tax rules of the IRS, yet he can't comply to them, and I've got a problem with it. Totally. I think we are making a mockery of this board with probation and $500 penalties for somebody that didn't file tax returns, knowing full well he's probably one of the most qualified in understanding the tax laws that there is out there for however many, and it was a bunch of years, 97 to 2005. I have a problem with it, and I don't know what, and
But and I don't mean this to sound how it's going to sound, but it's a request. It's either a yes or a no. And, just because I look at certain parts of the facts from a legal perspective and say, I'm not sure about this, that doesn't mean it's my recommendation one way or the other. The facts are, and the record reflects, that he signed what he signed. And he's got to live with that until and unless the board decides to act otherwise. And if they don't, then they just don't. And if he doesn't like that, then he shouldn't have signed that, and he should have taken his chances at a formal. And now, I doubt that it would have turned out anywhere near that result, but, that's...
But he's on probation now,
Yes,
and he's asking to have that lifted?
yes. It's been, 15, 16 months, something like that?
Probation began June 29th, 2012, and it was scheduled to go through June 29th, 2014, and he wants it lifted now so he can apply for a teaching position.
And reasons for that and in support thereof, that is for Mr. Gee to explain and not myself.
Question unless there's a motion on the floor.
Well, the discussion, the motion is tomorrow.
Right. But I meant the
Yeah.
recommendation to the board.
Right. Well, we don't have a recommendation. We aren't being asked to make a recommendation, are we?
I was asking if we could.
No, I said you could if you wanted to. I don't know of anything that's stopping you. So if there is a sense of the committee, then
I'd like a little more information before a person.
you'd like to hear from him in person, because he'll be here tomorrow.
I know what you're saying. I just.
I
I'd like to-
understand. I've spoke my piece.
You didn't hold back at all.
Did you expect me
You
to?
gotta start saying what you really feel, Mr. Royston. It'll make you old before your time, holding back like that.
You can get it back on the reruns.
All right.
Like Mr. Blofeld and be a little more timid.
Yeah. Well, we've got a new board member that's right in there with us, so I'm proud of her. Is there any more to come before this committee today? If not, I would entertain a motion for adjournment.
So moved.
Second, all in favor, say aye. Bye. Aye and bye.